Hey guys, it's Kathy. Welcome back to Court Vibes. So today we have some good ones, but I'm going to warn you, you're going to have way more questions about life in general after today than answers. Because I don't even know what happens in this first court case. It goes from questioning what's going on to chaos, just chaos. And we never get an answer on anything. But it's in here, and we have a couple other ones. We got an attorney that gets chewed out by the judge. That's pretty funny. And then we have an inmate that's coming up that blames everybody else for what he did. Oh, we also have the perfect judge. It's a real short clip, but during this time, when this judge gets thrown this person, he handles it perfectly. And then I think probably it happened 2 days ago. This last clip you might possibly have seen elsewhere, but I put it in because it was my first time seeing it today because I worked over the weekend. And it was good. So yeah. Send yourself to jail is all I have to say. You were supposed to make a special appearance at jail and you haven't. So we'll see someone avoid jail again later at the end. So here we go. Let's get started. Today's the first time I saw Wanda. I know I've never recorded her before. And if you're wondering, all my first videos that I made, I had to take down. Because apparently, see, I like commentary, but I don't like it a lot. So the first videos that I put up were just the court videos and not me involved at all. Well, apparently YouTube doesn't like that. And I have to say something to you guys or it goes against reuse and I'll get in big trouble, blah, blah, blah. So I had to take them all down. So when I was taking them down, I was looking at the judges I was taking down, and I haven't seen her in there. I haven't done Wanda yet, and I love her. I love her. I love this judge, and I feel bad because of everything that happens today. Yeah, it's just confusing, and the audio is not great, but the parts that you do need to hear, you can hear a lot better. Right now, they're just sitting around talking, waiting for the judge. Now, I mean, it'd be nice if his lawyer was talking to him right now. And he's talking at his lawyer right now. And we're just waiting for the judge to come in.
The judge is on her way.
It's not for my. So I don't have to cuss nobody up. I know she gonna do something. I'm here because I want to be.
He just said, I'm in here because I want to be, and that's facts. The only reason why he's sitting in this chair right now is because he wanted to be here in this chair right now.
I came down here and ate. You ain't gonna tell me what's going on. I'm right. Yeah, you're right. Yep. When I leave this jail, next time, not on purpose. I'll be able to go to what state I want to go to, and I won't have to worry about losing my job and I'm making $2,000 a week.
He did that because he was put on probation instead of jail. And when you're on probation, you have to follow all these rules. And if you don't, then you could go to jail and lose your job. So he doesn't like probation.
Because my days are wrong. This case is messing with my life.
There's Wanda.
But it says
She's trying to read these sheets to understand what's going on here. But there's no answers on that sheet to what is going on today. Just more questions.
Parties on Jones. This is case number 223852, State of Michigan versus Ravon Jones, scheduled for arraignment on a tether violation. Appearance for the record.
Good morning, Your Honor. Agent Ryan Sobey on behalf of the Department of Corrections.
Good morning.
Good morning, Your Honor. Wyatt Harris, 854-891 on behalf of Ravon Jones, who is to my right.
Good morning. Stand station there for the record, sir.
I was on probation, not a tenant.
She said, stand and state your name for the record, sir. He stood up and said, yeah, it's probation, not a tether violation. So that's how this is all going to go, by the way.
See, thank you.
She just rolled with it. You can see her getting more confused every word she reads.
All right. Counselor, you want to arraign your client on the warrant?
Yes, Your Honor, we waive some reading of the information.
All right, the court will set aside the warrant. The warrant was issued on July, oh, wait, look at this. Sentenced to probation on October 25th, 2022.
I don't know why there's a warrant. This warrant is confusing her completely. I don't know why there's a warrant. I would think after his actions and where he did the actions, he would be arrested then and there, and then there was no warrant needed. But a warrant must have been filed for what he did instead of him being arrested. I don't understand.
You have a copy of the warrant, Counselor?
I do. I have disorderly conduct. I don't have a warrant.
Okay. So, I'm not a lawyer. I'm not a lawyer. But one thing I do know is if I had to use a lawyer, the warrant is the first thing that they have, because like a lot of cases just get thrown out because the warrant's not right. The date's wrong, the address is wrong, the time is wrong. They're only allowed to search for like what is on that warrant and not, I think it's called fruit of the poisonous tree or something. You can't get anything else. So the warrant is like a big deal. It's like the first thing a lawyer is supposed to look at to make sure everything's right, because they could just throw the case out. This lawyer has no warrant.
I just have an incident report.
I'm pulling up the warrant. Let me look at this. They also have a copy of the incident report that says disorderly conduct. That's what you have, Tom?
That's what I have, Your Honor.
All right, just a moment. Do I have it? Oh, I think what I'm looking at is let me print out a copy. What I'm looking at is a warrant. It's not signed by me, but it's dated July 21st. I'm not sure who signed this. This court was not in session on Friday. I can't tell if this is signed by another judge. Let me see this. I can get that. 3 pages. All right. So I see that it was signed by Judge Chandra Baker Robinson. I see. All right. So a warrant was signed on Friday. And I just ranked him on that warrant. Now, Mr. Jones, you have a right to have a lawyer represent you, and Attorney White Harris is doing that today. And you also have a right to have a hearing in this matter. Now, do you need some time to talk to your client about this particular warrant?
Yes. His client is in jail. So obviously he's not speaking to his client often. She just said to him, after she gave him the warrant that he didn't have, hey, do you want some time to speak to your client real quick? Yes. The answer is yes. Please, yes. I need to speak to my client real quick. Because I'm about to do some stuff in here. We're going to plead this down. I need to tell my client, what's about to happen. Nope, 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 nope. That's not what happens. All he had to say to this question was yes. Please, yes.
No, Your Honor. I know exactly what it's.
I'm sorry?
I know what it's.
See? Did you hear what I said then? No, I don't need to speak to my client. I know what's going on. Well, yeah, you know what's going on, but that's not going to help you in a second, dude. You're headed right into the iceberg.
All right, so this is a violation of probation. And we also have a incident report from the Wayne County Sheriff. How would your client like to proceed today?
Your Honor, you would admit to the violation.
All right, let's swear Mr. Jones in.
Mr. Jones, please stand and raise your right hand. Mr. Jones, please solemnly swear to affirm the testimony you be giving today is the truth and nothing but the truth.
Yes.
Thank you.
I didn't think about what happened. I didn't know.
Don't speak out in this courtroom until I address you. No more words. You may proceed. What are your client?
Your Honor, I've had a conversation with my client about the incident that occurred on 7/21/23, and it matches what the violation of probation is. I'm trying to admit to
Ward, dear, your client. I need to ask your client
Mr. Jones.
to make the admission.
On 7/21 at the 23 on 11/51 on that day.
No.
Did you try to enter the building with Frank Murphy relatives?
No, I did.
Okay, so you entered the building, okay? And did you try to have the sheriff, did you make contact with the sheriff?
I did.
And did you ask that sheriff to arrest you?
I did.
Okay. And you learned that you could not be arrested, is that correct?
Correct.
And when you learned that you could not be arrested, you exited the building, is that correct?
Is that this building or the building?
Frank Murphy, yes. This building,
I went to the jail first. Then the jail directed me to the court.
right?
Then the court directed me back to the jail.
Okay, so, but you exited Frank Murphy out of the court.
Correct.
And was it at that time that you picked up a pedestrian crossing sign?
Correct.
And was it at that time that you tried to use that sign and threatened to break
No.
a window?
No. So that's the part that I would say.
Okay, hold on, I'll get to it. What did you do with that sign, sir?
I asked the officers, can you arrest me? I went outside, came outside, I walked towards the vehicle. The officer told me to put the sign down. I immediately put the sign down.
Okay,
The officers then stated they sat outside and talked to me for an hour
okay,
and told me that I need to just go home and that I should not go to jail because it's people because they in here and they trying to get out. What they wrote in that statement is not what happened.
okay. Did you do anything?
I never did anything for threatening me. The officer never grabbed the,
Mr. Jones, wait until your lawyer asks the question and respond to his question, please.
Did you do anything with that sign in a threatening manner?
no,
Okay. So you did not try to
no. I never.
Mr. Jones,
No.
Mr. Jones, let your lawyer ask the question. Complete the question and then respond to it. You may continue, counsel.
Thank you, Your So you did not use that sign in a threatening manner?
I never raised the sign towards the car. And if they said that I did, then they can pull the cameras.
Please listen to my question. You did not use that sign in a threatening manner?
No, I never raised the sign at all.
Okay. Your Honor, I think that we have to have a meeting.
You
All
think?
right. Hey. Mr. Sobey, is there anything you'd like to say?
No, Your Honor, I would indicate that the defendant is on probation for a misdemeanor. He was sentenced, as you said, on 10/25 of 22. Estimated discharge date was 10/25 of 23. We did submit a discharge on July 11th because he was doing well. He completed a handgun class. The only thing he had left to do is he hasn't made any payments, Your Honor. Up until this violation, he was in compliance.
Wow.
Except for the payments.
Wow.
All right. So
Well, guys, we don't get to get any of our questions answered. I have a million questions right now. I need to know why he wanted to get arrested. I need to know what's going on. Nope, it's over. Now everything falls apart.
we resume.
May I have your attention, please? May I have your attention, please? There has been a fire emergency reported in the building. Please evacuate the building by the nearest exit. Do not use the elevators.
Okay, pay attention to this lady right here. I don't know if you can see my mouse. So she's on the top right square, and she's sitting to the left of the top right square. She's like purple on her shoulder and white on her shoulder. Pay attention to that one.
We'll be in recess. I'm going to get my first drink.
Judge is out of here. Judge is like, bye. See y'all later.
May I have your attention? May I have your attention, please? There has been a fire emergency reported in the building. Please evacuate the building by the nearest exit. Do not use the elevators.
Mrs. Stolby, we're all evacuating the building, so. Yeah, okay. So we'll come back to you another time, later in the day or tomorrow. We don't know.
Okay.
All right, thank you.
May I have your attention? May I have your attention, please? There has been a fire emergency.
Here's my public service announcement for the day. If there's a fire emergency in your building, leave. Leave. Just leave the building. I mean, I grew up in the 80s. So we all saw those videos where the stadium catches on fire with all those people in it and the whole thing is on fire within 4 minutes. You'll leave the building. I think we have to stop, drop, and roll out the building. I don't know. And then look both ways before you cross the street. But look, she's old enough. She knows that if you get under your desk, that'll stop a nuclear attack, a hurricane, and a tornado. So she knows that you need to leave when there's a fire. And there's nothing at your job worth this. Nothing. Okay, she doesn't get hurt. Nobody gets hurt. Don't worry. There's the judge. Judge is back because she forgot her coffee. And if there's a fire emergency, I might run back in for my coffee. I don't know. It'd be nice and hot.
All right, and then the deputies will take us out.
Well, aren't they getting
May I have your attention, please? May I have your attention, please? There has been a fire emergency reported in the...
Dum-dee-dum-dee-dum. Take your time. Don't worry about the fire emergency. Look, the judge is leaving. I heard clicking. I don't know what that was. I don't. I don't think it was a stapler, though, guys. Oh, gosh, lady, get out of the building. You're stressing me out.
There has been a fire emergency reported in the building. Please evacuate the building by the nearest exit. Do not use the elevators. May I have your attention?
I don't know. The judge sits on the bench, and then there was someone in front of her, and then she's down here. So I think she's the court reporter, not Madam Clerk. So pay scale wise, she should have been the first one out because she doesn't get paid enough for that. But she's finally out, and she's safe, and they all come back in a few minutes and go on to the next case. He goes back to jail, I assume, and we don't hear any more about him. So I don't know why he tried to get arrested. I don't know what happened, and I don't know if I ever will. So now we get to this next guy. Oh, this lawyer. Here we go.
Hello?
Oh, you about this judge. Oh my God, it cracks me up. The way he runs his court is he sits there when he's ready to call a case and he says, hello, 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 hello. And then out of nowhere, people pop up and they're like, okay, judge, we're here. But he does it for all the cases. And it's hilarious. It cracks me up every time. Here they come.
Good morning, Your Honor.
Good morning. What brings you here today, sir?
I am here for two things. One is a pretrial conference. The other is a motion for summary disposition hearing.
Wrong. He's here to get his butt chewed out by a judge.
I have a case number for you if you'd like it.
What's the pretrial?
The pretrial is, at least we have a hearing date for it. I think it might have been replaced by the MSD hearing. It's for Lake Trust Credit Union versus Sharif Jameh.
I have Mr. Jameh here. Let's get started on that file.
Zlojutro. Wait, how do you pronounce his last name? Zlojutro. That hurts my head. I don't know how to say that.
Hello? Hello,
Hello, Your Honor.
what is your name?
Sharif Jammeh.
We are on the record calling file number 231439110, Lake Trust Credit Union versus Sharif Jama. This is the date and time for what appears to be our second pretrial. Your appearances.
Good morning, Your Honor. Daniel Zayutro for plaintiff.
You
Zoyutro.
member of the State Bar of Michigan?
Yes, sir. P number P85174.
And your name again, sir?
My name is Sharif Habib Jammeh.
All right. Did you gentlemen do any written discovery? We opened your written discovery on June 23rd. What's going on with that?
Discovery was opened, Your Honor. We have not sent any written discovery.
And how about you, Mr. Jamal? You planning on doing any written discovery?
No.
Okay. Counsel, how about you? You going to do any written discovery?
It depends on the outcome of today's motion hearing. I'm
There's
not.
no motion on the docket today, sir.
That's news to me, Your Honor.
Well, your claim of having a motion is news to me.
Yes, understood. In which case we can send out that written discovery. You're positive you don't have an MSD hearing today?
I have a note that a motion was filed, but it is not scheduled today.
Do you have a scheduled hearing date? I think our files on my end got screwed up.
No, I do not have a hearing date because there was just, either yesterday or the day before, there was just a Court of Appeals decision criticizing doing summary disposition motions before discovery was closed.
Make sense?
Fair enough, Your
On
Honor.
my calendar a motion before discovery was closed.
No, makes sense, Your Honor. I apologize. I can work on that written discovery. I believe you opened it for 60 days at the last pretrial
I
conference.
just
Which,
opened it. I did not give a time. Counsel, you're trying to put words in my mouth or you're trying to run my docket. Neither one of which I'm happy about.
understood, Your Honor.
This is what we're going to do.
Yikes.
We're going to give you gentlemen another pretrial date. That pretrial date will be August 18th at 10 o'clock. Does that date and time work for everybody?
August 18th at 10 a.m. works.
Does that work for you, sir?
Yes, sir.
Okay, we'll see you then. If you're going to do any written discovery, let's get it done.
Yes, sir.
August
Yikes.
18th at 10 o'clock. Thank you both for coming in. We
Thank
are
you.
on record.
And
787.
Okay. The audio isn't great for some of this, so I'm gonna, try to fill you in on what he's saying. But the audio for the good parts is fine. It's just fine. You just missed some of the other parts. So at the beginning here, it sounds like he's thanking the judge. He's being kind to the judge. He's saying kind words. No, he's not. He's not. He's thanking the judge for wasting his time and making him wear handcuffs. And she just rolls right past it.
Good morning.
Good morning. How you doing today?
Very good. How are you?
I'm great, thank you. Thank you, Ms. McDonald, for the 5 days and everything. Not wasting my time with these cops going back and forth.
I missed that the first time. He said, "Thank you, Miss McDonald." He's talking to the prosecutor, not the judge.
All right. So let's go over this form here, Mr. DePape. I have on this case a document entitled Statement of Defendant on Plea of Guilty. It states that your true and correct name is Eugene Gallardo DePape. You're 42 and you have 10 years of education. Mr. DePape, you are charged with criminal trespass in the first degree. Did you understand what the city would have to prove to convict you of that charge?
Yeah, pretty much nothing.
Okay.
Attitude.
And did you understand that when you enter a guilty plea, that you are waiving your constitutional rights? They were listed in paragraph 5 on this form. Did you go over those rights with your attorney, Mr. McCluskey, and understand those rights that you give up? The city has indicated the recommendation that they'll make to the court on your plea of guilty. It's listed here in paragraph 6. Did you understand what that recommendation would be?
Yes, ma'am.
Did you understand that I don't have to follow that recommendation?
Yes, ma'am.
Mr. DePape, if you are on probation or parole or not a citizen, entering a guilty plea and getting a conviction can have negative consequences for you. Did you understand that?
Yes, ma'am.
Other than the city's recommendation, has anyone made any threats or promises to make you plead guilty today?
Mm,
What is your plea to the charge of criminal trespass in the first degree?
guilty.
In paragraph 11, there's a written statement. It reads, on July 15th, 2023, in Lake Forest Park, Washington, I did knowingly enter or remain unlawfully in a building. Is that your statement?
Yes, ma'am.
Mr. DePape, I will find that you're making a knowing, voluntary, and intelligent waiver of your rights. I will accept your plea of guilty. I'll find that there's a factual basis to accept your plea, and I'll find you guilty of the crime of criminal trespass in the first degree. Other than the written recommendation, does the city have anything to add?
Your Honor, it does look like that he is going to be likely booked on those felony charges. He's going to be facing, looks like, some significant time on those. That did go into consideration in the city's recommendation proper to the court. So I would ask that the court accept that.
All right, Mr. McCluskey, I'll hear from you.
Thank you, Your Honor. This is an agreed recommendation and defense is asking the court to follow it. I did satisfy my obligations under Padilla and Sandoval. As for any future legal financial obligations, given the fact that Mr. DePape will be in court elsewhere, Your Honor, I do not believe he'll have an ability to work and therefore he would not have the ability to pay any future legal financial obligations. Therefore, I would ask for relief under Blazina and ask that you waive all non-mandatory cost fees and assessments.
All right, that just ticked me off a bit when that happened because, again, I'm not a lawyer, so I don't know if I'm right or wrong, but that's his lawyer. That's his lawyer. His lawyer just got up there and said, yeah, you know, I go for the recommendation, and I did as much as I had to under this rule or whatever. And now I want my lawyer fee from the city, and don't make me try to get it from him because he's broke. Like, that's his lawyer. So he just pled guilty to criminal trespass. But apparently he has all these other cases that are going to put him away for longer. Nobody cares about this trespass at all. So, like, when you plead guilty to criminal trespass, then that could hurt him criminally later in these other cases, right? Like, shouldn't he have pled no contest? And then they couldn't use the fact that he pled guilty to this later. I don't know if McDonald said no, he has to plead guilty or not, but I bet you she would have taken a no contest because nobody cares about this thing right here today. There's bigger fish that he has to deal with later. But his lawyer is just like, yeah, I did what I'm supposed to do. Now, I really do want to get paid though.
Mr. DePape, you are able to make a statement if you like.
Oh boy, here we go.
Anything you want to say?
I just want to say, I think it's time for me to stop getting drunk and passing out in places.
There, thank you. He just took responsibility for his actions. I think it's time I stop getting drunk and passing out places. You think that, he understands maybe he made a mistake and that's not appropriate behavior for a human being. Nope. Now he turns and blames everybody else.
Like in bathrooms and
That's
accidents.
probably a good idea.
I didn't understand, the whole, there was like 6 security guards there that night. One of them could have woke me up and said, hey, you need to leave this premises, and then told me not to come back instead of just trespassing me and then calling the cops on me. But I did pass out, and
It's like it was almost 2 a.m. when
yeah, but it's weird that 6 security guards, none of them saying anything to me about leaving the premises. All of a sudden come at me trying to hit me with a burglary and all this craziness. And then all of a sudden, I'm trespassing.
well, at that hour, no one was allowed to be there anymore. So I
I
understand.
understand that part, but I'm saying, like, wouldn't you think somebody would go check a bathroom to make sure that you don't have somebody passed out or dying in their restroom?
Okay, guys, now we know. Okay, we learned 2 things today. If there's a fire, leave the building right away. Also, if you own a building and you have a restroom that the public can access, every once in a while, check it to make sure someone's not passed out or dying. Because, it's just rude of you not to. It's just rude of you not to. Because now he's going to jail.
Like 6 security guards? Why do you even bother paying these guys to be security guards in their building if
They
they're
don't
not
really
going to come in there and be like, hey, sir, you need to wake up and move along? Because even if I'm passed out in there, somebody should have said that to me.
Well, is there
Instead of, like,
anything else
charging
you need
me
to say
for
before I sentence you?
Oh, also, I'd only like a year probation of being trespassed for a year. I think I deserve that much at least. Yeah.
Well, you have been trespassed in the town center, so they have their own trespass. This is whether the court puts you on probation as part of this
For like a
case.
year. Could it be a year? It's up to you, ultimately. That's what my attorney told me anyway.
Well, what I impose for sentence is up to me. Whether they want you back in that store, they have the right to trespass you, independent of me.
I wasn't in the store even. I was in the
But in that
restroom.
mall after hours. So do you understand what I'm saying?
Yeah, that's fine.
Even if I don't impose a criminal trespass order as part of the sentence here,
Right.
if they've trespassed you, you must abide by that. Or you
That's
must be
fine.
arrested.
I can deal with that.
I just want to make sure you understand there's 2 different systems going on.
I understand that.
Okay?
He's still talking about the security guards.
All right, Mr. Pape has quite a bit of criminal activity and other charges that he will be answering to. So my sentence will be as follows. Pursuant to Blazina, I'm waiving any LFOs. I will find him indigent as
There you go,
of
lawyer. You
today
get
if he's
paid.
unable to make payments. So the fine will be fully suspended, 5,000, 5,000. The 6 days or 5 days, is that the credit he has on this matter? So you've calculated that.
I believe so, Your Honor. I have 7 days, I think, to discuss Friday, right? Thursday, today's Monday, right? It's about 7 days.
All right, I will impose 365 days or 364 days in custody. $354 days will be suspended. That will be 10 days. You have credit for 5. Case will be suspended for 24 months. During that 2-year period, Mr. DePape, you're to have no criminal law violations. You're to have no contact with the Lake Forest Park Town Center. And Ms. McDonald, I am not going to impose treatment obligations. I don't believe that that will be fruitful in this case. Mr. DePape has much bigger cases that he needs to answer to at this point.
I was wondering, since I have, today's my 7th day. I came in, I believe on Friday, right? Friday night. Friday, Saturday, Sunday, Monday, Tuesday, and today's Wednesday. Today's my 7th day. Could you write on my paperwork credit for time served so they release me today?
I am putting that I've imposed 10 days. They will give you the credit for the time that you have served, and they will calculate that out. I believe you have credit for 5, but if the jail does a different calculation, but that's my order today. I'm not going to impose a treatment obligation, but I am imposing a 2-year suspended sentence.
So 10 days would be pretty much Wednesday, Thursday.
I don't know. It's not for me to decide right now. I've imposed a 10-day sentence, so that will be calculated by the Snohomish County jail facility.
Okay, thank you.
You're welcome. I do have the voice of Janice as well. All right, Mr. McCluskey, I did, Mr. McCluskey, on the statement of defendant on plea of guilty, I did see an electronic signature. Did you apply Mr. DePape's signature with his permission?
Yes, Your Honor.
Thank you.
So let me get it worse. We got it today, but I actually got one. So basically, I won't be leaving Snohomish County for the whole weekend. If you were to get out of there this week, if you were brought in on it's Friday, so I'll be able to leave Snohomish County on Friday morning.
He just doesn't understand that the jail is going to tell him when he can get out. And it's not always fair, but, you know, my guess is he does have 5 more days. Minimum 4 more days. My guess is that's what they're going to credit him. He thinks he has 7. He maybe has 6, maybe. If he came in on Friday night, they're not going to count that as a full day. Hey, this is nice and short and perfect. This judge is perfect with this situation.
All right. Good morning, sir. Can you state your name for me?
I was Matthew Joseph Jansen of Indianapolis.
I didn't.
Thomas Jansen of Indianapolis.
That's Mr. Jansen.
Mr. Jansen. Okay, here we go. All right. So, Mr. Jansen, you have got one charge, that is criminal trespass. That bond amount is $1,500. That's a misdemeanor. That comes with a special condition that you are not to return to the airport, Jackson Airport, while out unless you are in possession of a valid ticket for travel on that day. I'm going to schedule your preliminary hearing for August the 8th, unless you want to waive that hearing. Do you want me to schedule it?
I like to hear it right now.
We'll hear it August the 8th, unless you want to waive the hearing. Do you want me to schedule you for August the 8th?
Waive it.
If you want us to cancel it. If you want to give up the right to a preliminary hearing. So let me go ahead and schedule you for August the 8th, and then that way you can talk to an attorney about it. All right? Would you like a public defender to represent you?
Yeah, that's fine.
All right. Okay, based on your application, I find that you do qualify for a court-appointed attorney, so I'll put in the order today to appoint somebody to represent you, okay?
Yeah.
All right, thank you, sir.
I see January 15th, Martin.
Thomas is...
Oh, I wanted to hear what he had to say so badly. I don't know what would have came out of his mouth there, but I do know it would have been lovely. But the judge wasn't having it, so we don't get to hear it. This one, I'm on the side of the wife with this one. She's just trying to explain, and I guess the judge is on the side of the attorney, and he's right. He's right. She's not supposed to talk at all, but this guy's struggling to get his point across. So yeah, we'll see.
Introduce himself to the record.
Sorry about that.
Morning, Your Honor, for the record.
All right, so we're...
Sorry about that.
So, Mr. Hill, you're here for Midland Credit Management?
Yes, sir. I'm covering this today for Midland Credit.
All right, and sir, you are Jeremy Thomas, that's correct? You'll have to unmute yourself, Mr. Thomas.
His wife got it, don't worry.
Yes, correct.
All right, I'm going to call to the record docket 22010101010. That's it's Midland Credit Management versus Jeremy Thomas. Will the parties please introduce themselves to the record?
Morning, Your Honor. For the record, William Hill, P. 28608, appearing as coverage counsel for Midland Credit.
And sir, you are Jeremy Thomas, is that correct?
Correct.
Now, this is the time set aside for this morning for an objection to the periodic garnishment that was brought by yourself, Mr. Thomas, is that correct?
Yes.
All right, and then I have a response to the defendant's objection pursuant to 3.101, and that was filed by Mr. Hill. Is that correct?
Midland's office filed. I'm not sure who the attorney.
Okay.
May have been that way.
I have it. Let's see.
Andrew Perry.
Stephanie Petway.
Yes.
Okay. Mr. Thomas, you may proceed with your objection to the garnishment.
My objection's been filled. They sent my state taxes to Midland Credit. They received $1,218.28 as of 6/1/23 of this year. And they have garnished, they're still continuing to garnish $755.61 total since then.
So what is your understanding of the outstanding debt? I have a total judgment, it looks like, of $1,213, which was a total judgment. Is that correct?
Yes.
That was the default. I have $1,118 plus costs for a total judgment amount of $1,213. I just have that as a default request. So you're indicating that you're indicating today that they've met that $1,238.38 threshold. Is that what you're saying?
Yes.
All right, Mr. Hill.
Your Honor, there was a default judgment that was entered on July 27th, 2022. Interest has accrued on this. Mr. Thomas is correct. There was an income tax garnishment that was on June 1st. Those funds had been released. We're showing that once the funds are released, there's a current balance owing of $114.33.
So that part confuses me a little bit. They went to court, and in July, the judge said, you owe this much money. And what he just said right there is, yeah, okay, he's paying that much money, but now there's interest on there too, which I understand. I understand interest on loans. I do. But if the court rules that you owe $1,281 or whatever, and you have a garnishment, you win a garnishment on someone's paycheck, are you allowed to just tack on what you think is interest onto that judgment? Or is that interest something you have to collect in a different way or later or through another judgment or whatever? I mean, I just feel like they shouldn't be allowed to just tack on interest whatever they want. Like it didn't sound like the judgment said that it's this plus interest. They said it was this much money. He just said it a couple times. He said it was this plus court costs equals this. Well, they're adding on interest, and not only that, they garnished his income tax check, which covers all of it, except for this extra interest. All of it on June 1st. It's, okay, so today's the 21st, but this actually happened on Friday. I just didn't have time to record it till today. So this was a couple days ago, but still, it's almost 2 months later and they're saying that, it hasn't released, but still, they're not allowed to charge interest if they have the money. I don't know. All
right. So after the funds are released, Mr. Thomas,
there's an outstanding balance of $114 based, and I'm assuming that's based on the statutory interest that's accumulated, Mr. Hill?
Yes, sir.
Okay, so Mr. Thomas, you have an understanding that once those funds are released, that all that's left to pay on that debt is $114?
Yes, and I'm asking for it to get released.
Okay.
I'm asking for that 114 to get waived.
Right. Well, I'm not willing to do that today. That's a part of the debt, and it's part of the statutory interest concerning the debt.
All right, statutory interest.
That's not a valid claim. The claim here is it's for some reason the garnishment is beyond the actual debt, and that is a part of the debt. So I don't see that pursuant to 3.101K, I don't see that this is that's really what you're indicating is you don't like the underlying debt, which is a problem with the actual default, but that's not a problem with the garnishment, as I see it.
I have requested a history, and I haven't received that.
All right. Well, I think you just received that on the record, but I'm sure Mr. Hill can give you the numbers or send it to you for the last $114 that is left after the funds are released, which it appears Mr. Hill indicated for the record that the funds were released, that his understanding is that you are correct. The last garnishment left a balance of $114.
That's what my records are showing right now. That's what they gave to me. So
all right.
If the funds were released to plaintiff, he might be entitled to some of the money back.
And that's the issue. So the husband doesn't say it, but that's the issue. They are about to garnish $700 out of his next check when he only owes $141. And they want him to stop. They don't want him to do that. They don't want them to take the $700 and then refund it back. Because, I mean, if you think about it, they're in court because he didn't pay them in a timely fashion. So do you think they're going to pay him back in a timely fashion? I know it's not fair. He did it to them. So, but that's what the wife is upset about.
Okay. But we're showing as of last night, okay, there was $114.31 owing and the withheld funds at the release to the plaintiff that should satisfy the judgment. There was personal service made on this back in June 21st, 2023. It was a credit card debt, okay, with Community Bank, with Wayfair was the original creditor. Credit card was opened up on June 4th, 2020. The last payment, it was defaulted a year later on July 31st, 2021 and sold to Midland Credit. They purchased it.
Right. So it sounds, Mr. Thomas, like if the funds were released, and it sounds like your indication for the record as they were, is that the majority of the debt or all the debt, the ledger shows $114 is what's left. If it comes back to 114, that's the remainder of it. But I don't believe that your objection to the garnishment is valid at this point. It sounds like you had a problem with the underlying debt concerning the statutory interest. So I'm gonna deny the motion. I'm gonna deny the objection to periodic garnishment.
Excuse
based
me.
On what's
sir, Judge. I'm
Ma'am, I don't know who you are.
Okay, I'm Christina Thomas. I'm Jeremy's wife, but I don't think that I'm here with him just to try to help him explain this. What we're asking is for a release of the garnishment from his employer because his employer will not stop the garnishment until they get a release order signed from the judge. So the employer has taken $755.61. After the $114.30 is paid, $641.31 should be returned to Jeremy. That's what he's requesting today. We were told by Midland Credit last week that the judge would have to sign the release order today in order for the funds to be released.
Ma'am, I can't hear you.
Okay, we were told by Midland Credit last week that the judge would have to sign the release order in order for the employer to stop the garnishment.
All right, well, I'm willing to sign once the complete garnishment has been taken care of. Once the complete debt has been taken care of. There's still $114 out.
Yes, that's what we're trying to explain. That since that balance has been paid, the garnishment did not start until after June. And that's what we've been explaining to Midland Credit, and we're trying to explain to you. $755 will cover, that's what's been taken in June from his employer. In order for his employer to stop taking 25% of his wages, we need a release order signed so that the garnishment stops.
All right, well, Mr. Hill?
Your Honor, we'd ask that the objections be denied, the funds be released to plaintiff. Once the judgment is satisfied, the remaining funds that would be above the $114.31 would be returned to Mr. Thomas. So we're in essence asking for the same thing. We're asking for the garnishment to be released to the plaintiff to satisfy the debt. The balance of the money held is not going to be kept by Midland, okay? They're going to refund it to Mr. Thomas. We're showing $114.31 owing, and that's it, as of today. So it sounds like we're on the same page.
That's why we're asking for the garnishment to stop, because his employer has already exceeded
You
that.
are not an attorney, ma'am. Please don't argue.
Excuse me, Mr. Hill. Please don't disrespect anybody like that. I'm just speaking for my husband.
Ma'am, you're not even supposed to be on the. You're not even supposed to be on the motion, okay? So allowing you to speak right now is a flexibility that we're providing right now. All right. I think you're saying the same. Ma'am.
She's done. She's gone. No one ma'ams her in her own kitchen or wherever they are.
So what I'll do is I am going to deny the objection to periodic garnishments. But Mr. Hill, if you formulate an order indicating that the garnishment is to be released to the Midland Credit Union that will suffice the debt, which I think is what you're indicating.
Yes, sir.
Well, that would mean that the debt has been paid and the garnishment can stop. And is that a fair statement, Mr. Hill?
Yes, sir, it is. Okay, we're going to immediately stop the garnishment. Okay, once the objections are denied, the funds are released. Okay. So the employer would typically send it to the to the plaintiff in this case. The judgment would clearly be satisfied, and the money would be returned to Mr. Thomas. So that's typically how it works. So the judgment would be satisfied.
Right.
Garnishment would stop, the money would be released, Midland would be paid, and Mr. Thomas would get a refund.
Right. All right, so I'm going to deny the objection to periodic garnishments. My understanding, based on what's been said on the record, is that Mr. Hill will follow up with an order to that effect, which will indicate that the satisfaction, the debt would be paid, and therefore the garnishment would stop. They would stop garnishing your wages, which is what you want, Mr. Thomas, based on the order that I signed. You're really asking for the same thing in my regard. I mean, I think Mr. Hill's correct. I think you're really asking for the same thing. What you want is you want them to stop garnishing your wages based on what you represented. That'll happen as soon as I sign the order, and that money is released to the plaintiff to satisfy the debt. Is that a fair statement, Mr. Hill?
Yes, sir, it is.
No, it's not, and here's why. If they would have just provided this documentation, which they could have, in June, so it's a couple days away from August right now. So on June 1st, they took like $1,200 or whatever for his income tax, or they garnished his income tax. Why he got it in June, I don't know. Anyway, he got it in June, they garnished it. And then he only owed $141 left. In June, they garnished his check for $700 some. So he has already, as of right now, overpaid. And it's July, and they're going to garnish again, and they're going to garnish again, and they're going to garnish again. If they would have just showed that the debt has been satisfied, then the judge would have maybe understood better that he needs to stop the garnishment right now because the debt has been satisfied, but they didn't provide that paperwork. I feel bad for them, and I can't stand Midland. No, we don't like Midland now.
All right. Mr. Thomas, do you have an understanding of, do you understand what we're doing is basically making sure the debt is satisfied so that you receive any, so they stop your garnishment, and also that you receive any overpayment. If there has been any overpayment, you'll receive that credit. You understand that, Mr. Thomas? And you'll have to unmute yourself. You're on mute again.
Your wife got it, don't worry.
I'm sorry, Your Honor. Yes, I understand that.
All right, and I don't want it to be taken out of context, Mr. Thomas. You're on the litigation. Understand that this is all getting sorted out in a way that legally makes. So what you're asking for is going to be done. It's just going to take an order from Mr. Hill so that the garnishment stops and the debt's repaid. Once that all starts, the process of that starts, you should be all set, because it appears, based on your representations today, that the debt is paid right now to 114, but maybe more so based on the release. All right, Mr. Thomas?
Okay.
All right. So I will sign. Go ahead, Mr. Hill.
You want us to submit, you want us to prepare this order and submit it to you under the 7-day rule? Would that be most convenient?
Yeah, I think that would be most convenient, Mr. Thomas. That means you can take a look at it. The order that the courts to send, and if you want to make sure that all that money's been, go ahead and submit the order, and I'll take a look at it and sign it under the 7-day rule. The ruling today is the objection to the garnishments is denied, but the order that I sign will recognize that that money has been released based on what you said, and the garnishment will be satisfied once the debt is satisfied, which it appears it's already happened. Okay.
Thank you.
All right. So that's so. Any questions of me, Mr. Thomas, concerning this? I know the ruling is against you, but the actual order is what you need in order to get this process started, so the debt will be satisfied, and then there's no reason to garnish, and the garnishment will stop. So, do you have any questions of me, Mr. Thomas?
No, I don't, Your Honor. Thank you.
All right. All right, that's all for the record. 22-01010.
I wonder if that lawyer is going to tack on attorney fees for this trial, for what they just went through, for this hearing, what they just went through. Because, I mean, Thomas lost. He lost. Are they allowed to do that on top of the interest? Are they allowed to tack on that to the garnishment? I don't know. I hope not. I hope not. Now, so for the rest of this last 5 minutes of video, you guys may or may not have already seen, this guy has been in front of this judge once before, and it's Savset, and it didn't go well. And from what I gather, it went so bad that he was held in contempt of court, and he was supposed to serve 30 days of jail. A year ago this happened. So, a year ago this happened. And God bless his lawyer. She tried so hard. But, like, I knew right away it wasn't working. So, she died on this hill. And she shouldn't have. Because, you know, lawyers can read judges. And they know once a judge has had enough. Like, all the judges are the same. The second that they have had enough, they have had enough, and nothing is going to change them. Nothing. And you really, as a judge, I feel you really can't let people just disrespect the court and not follow the rules of court. You just can't. You can't allow it. You can't be lenient on it, because you need that. We all need that structure of the court, you know, to handle everything. So this is fun. Here we go.
So, Mr. Lockhart, Jamil Lockhart. All right, Mr. Lockhart, have we had this discussion before?
Yeah, I'm here on behalf of the defendant, Jamil Lockhart, and you're making a special appearance.
All right, well, you got to make your special appearance to the Wayne County Jail. I told you that the last time.
I love it.
Yeah, so I filed a notice of removal for all of these cases because I don't believe that this court is capable of acting in an unbiased way. But I mean, there's been no response from the city.
I wonder why.
To this point. I mean, just the last court date we had, perjury was committed. I mean, you guys put on the record that I failed to appear, and I spoke to you.
You didn't fail to show up to the Wayne County Jail. You were ordered to do 30 days in the Wayne County Jail. You haven't showed up. You still haven't showed up. So you're still disobeying. No, let's not do this. This is how it started the last time. You're still disobeying the court's order, and you have to do 30 days. You have to present yourself to the Wayne County Jail. You have a warrant out for your arrest. And before we go over this other stuff, you got to go. You have to go to the Wayne County Jail. All right?
Yeah.
Okay, so
I said what
I can increase the time if you can take to not be compliant.
Your Honor, I apologize for interrupting the proceedings. May I have a breakout room with this litigant, please, and thank you?
I don't know if he wants to speak to a lawyer, but he can if he needs to. He has that right to do so. You want to speak to the lawyer, Mr. Lockhart, or no?
Yeah, sure.
One room, please. We got Charles Owens. He's set for trial. A few more minutes on those. We'll start calling those cases. Who's on that 8-5-7 guard? What Miss Harris? What's gonna go with Mr. Lockhart? So I don't know why he's still sitting here.
Well, Your Honor, if the court will allow, we would like to attempt resolution of the matters that are on the docket. So I would ask if the court could stay the contempt proceedings and allow him to handle these matters.
No.
No.
It's been well over a year. No. He's gonna have to go turn himself in, and we'll deal with it that way.
Go to jail.
Your Honor, if the court could, just in the interest of justice and judicial economy, if he could resolve these matters, if he's still going to have to do the 30 days in Wayne County Jail, if at the time of sentencing, it could all be wrapped up together, just to not further delay his constitutional right to speedy trial?
He's delayed his rights. He's delayed his rights to a speedy trial.
And I do have a resolution, Your Honor.
No. I don't want to. I'm not even going to entertain it. That ship has sailed. We tried to give him that opportunity a long time ago. He kept being contemptuous in the court. He comes with these far out legal theories that he has that I quite frankly, don't know where he's coming from on that. No, I'm not gonna even entertain it.
Your Honor, I completely understand the court's position. I completely understand if he still has to do the 30 days in Wayne County Jail, but I think that he was potentially misguided, did not understand the finer points
of the
law, court rules, and courtroom behavior and procedure.
Nope.
So now that he has the assistance of counsel, which I'm not saying that he didn't have the assistance of counsel before, if the court would allow him.
I think he had Attorney Barry before. You know, the older guy with the dreads. I think that was his attorney.
We offered him counsel then. He denied the counsel. Go back and look at the video. It's got over 270-some thousand views on it. And I told him that 30 days will give him an opportunity to read up on the law and so he can make it and understand how this process goes. So go ahead to the Wayne County Jail. You can take some. They probably have some legal books there, and we'll hear these matters when you come out. So.
Your Honor, is any of this on the record or no? Or do
No, it's not on the record because I didn't call the cases. I'm going to continue on. That appears to be Charles Gard. Yes.
And that's it. He continued on. He said, nope, not happening. You can't make me. Yeah, I love that judge. I love it. Yeah, we had that. I can't remember. What was his judge? What was that judge's name? Judge Parker, who handled it perfectly. That was my favorite clip of the day because I don't know what that guy was going to say in jail, but just him saying his name cracked me up. So I wonder if that guy turned himself in yet. I'm guessing no. And, you know, I'm guessing. This is totally me guessing. I'm guessing that the way he's going to go to jail and do his 30 days is driving around with no plates. I bet you right now, knowing he has a warrant out for his arrest, he's driving around with no plates. He's going to get pulled over for that. It's been a year, so maybe not. I don't know. But no, if you made it this long, thanks for hanging out with me today. I hope you enjoyed the videos, and I know it's only Monday, but we'll get to the end of the week soon. Don't worry, guys. Have a great night.